Hello guys, welcome back to Teenage You Children Law Update family. Thank you so much for pulling up and supporting this channel. You are all amazing. Please click share and subscribe. Please also click the notification button to receive similar updates. In this video we discuss the recent court case of a 14-year-old boy whose parents sent him back to Ghana in West Africa to a boarding school in Ghana, but the child from Ghana applied through a solicitor to the High Court to return to the UK. Come with me as we explore the facts about the case, the principles that the court considered and the court decision. The 14-year-old boy applied through his solicitor towards the end of the year in 2024 to High Court of England for the court to place him under the supervision of the court, and he asked the court to return him back to England from the Republic of Ghana, where he has been living since the parents took him to Ghana in early 2024. On the 4th of September 2024, the High Court, without notice to the child's parents, made the boy a ward of court, which means placing him under the supervision of the High Court of England, and made some orders surrounding his day-to-day life in Ghana. At the next court hearing, both parents attended the court, and during this second hearing the judge ordered the preparation of a Section 37 report. I have done a video which explains the complexities of a Section 37 report, and you can connect with the link on Teenage You Children Law Updates. The backstory was that the boy's parents were worried about their son's disengagement with his education, and the parents were genuinely worried about his safety. Whilst then at his school in London, the boy was issued with an internal exclusion order for 2 days, following his part in a fight outside school. Also, while in London, this young person returned home with a swollen right eyebrow. Physical altercations with his peers predated the boy's move to Ghana. The family members would later in the proceedings give evidence to the judge of the boy going missing, frequently absent from school, wears clothes in gang colors, taking drugs and abusing alcohol. The parents devised a plan which they both recognize attracts legitimate criticism and involved a deception on their son. In late March 2024, both parents traveled to Ghana together with their son. The purpose of the trip was said to be a visit to the child's paternal grandmother, who, the boy was told, was unwell. Unbeknown to the boy, his parents had enrolled him at a college in Ghana, a co-educational international school, which appeared to them to offer an essentially British-based curriculum. The young person was outraged when he realized his parents were going to leave him in Ghana to attend the boarding school. The parents subsequently returned to England, leaving the boy in Ghana. At first, the child complied with his parents' wishes, thinking that he would be staying in Ghana for a short period of time, and he seemed to be happy. The boarding school initial end-of-term report is said to have indicated that he had settled well. The court eventually set the matter down for a final hearing. At the final hearing, the High Court judge considered evidence from the child's father and from the author of the Section 37 report. It became clear to the judge that there were no clear plans as to where the child would live if he returned to the UK, and the judge adjourned the hearing for this key issue of where the child would live in England to be explored further. At the adjourned final hearing, the court considered evidence from various people and professionals who knew the boy, including the parents, wider family, the social worker, the school, the child's family doctor, the police, and they all in various ways expressing serious concerns for the welfare and safety of the child. The Section 37 report in summary indicated that the child was likely to suffer significant harm if he returned to the United Kingdom. The report concludes that it is in the best interests of the child to remain in Ghana and attend the boarding school, as he will have a fair chance of excelling in life, despite wanting to return to the UK as soon as possible. Now we shall turn to the decision of the judge, and I will read out some of the judge's reasoning which illustrates the difficulties and complexities of the case. Inter alia, the judge said, the boy's going home to his family is simply not an option, though there has expressed a willingness to go into foster care. If that was the only way he could return to the UK, he has little understanding of what is involved in that option. I have no doubt that the For the Boy legal team have explained some of the realities of the care system to him, and in detail, but I share the school and parents' concerns about the maturity of some of the boy's decision-taking. From his comfortable and protected background, it will, inevitably, be difficult for him to absorb what Ms. Folks describes as the reality of becoming a child in care and all of the associated outcomes for such children, together with the risk of resuming his earlier associations and increasing his risk-taking behaviors. The boy's suggestion of finding alternative accommodation for him and his son struck me as an instinctive, loving and emotional response. It was, however, entirely lacking in any planning or resources. There can be no doubt that the boy's move to Ghana has been a big cultural shock to him, one which was unexpected and for which he was unprepared. Life for him there is very different. He balks at some of its inconveniences, especially the power outages. However, It is also important to remember that Ghana is an important facet of S' own cultural identity. His extended family in Ghana have gone to great lengths to claim him as their own and to help him to settle in whatever way they can, for reasons that strike me as entirely understandable. S may not always have been gracious in acknowledging the help he has received. S experiences in Ghana will generate in him a greater understanding of his own identity and that of his family. As is clear from my analysis of the evidence above, I consider that S is at real risk of suffering greater harm in returning to the UK than if he were to remain in Ghana. I recognize that this is, in many ways, both a sobering and rather depressing conclusion. What S requires, at present, is the support and love of his family whilst he navigates the challenges of adolescence. Though it is perhaps counterintuitive, I consider that he is best placed to receive and absorb this support whilst living in Ghana. He has regular contact with his father and family, not only by video contact, but by visits too. S has educational opportunities that he can choose to take up and expand. He is away from what I consider are the malign influences of the young men he has surrounded himself with. His extended family are able to support him and promote his security, alongside his parents. The judge decided that the parents' decision falls within what the judge regarded as the generous ambit of parental decision-taking, in which the state has no dominion. To the lawyers among us, the court considered the following legal principles during this boy's proceedings: the meaning of habitual residence, Gil-Lick competence, Article 12 of United Nations Human Rights Convention and Article 8 of European Convention on Human Rights and Section 3, Subsection 1 of Children Act 1989, which stipulates that in this act parental responsibility means all the rights, duties, powers, responsibilities and authority which by law a parent of a child has in relation to the child and his property. The court also considered Section 100 of the Children Act 1989 and the Child Protection Policy of protecting children from child criminal exploitation, which was recently updated on 18 February 2025. If you want to read the full facts and judgment, the citation of the case is S and F and another reported in 2025, EWHC from page 439. Family case reported on the 27th of February, 2025. If you were sent to your home country as a teenager, then please let me know about this in the comments below, or if you sent your child back home to another country due to your child's behavioral difficulties in the UK, then let me know your views in the comments below. Let me know what you think. Would you send your child to relatives in another country to ensure they get a good education? This case law update was provided to you by Teenage You Children Law Update. Connect with us and listen to news items, legal opinions, updates on case laws, legislation, new governmental policies affecting the social care and social work sector. The beauty of it, you can listen on the go and at your convenience. Please subscribe to Teenage You Children Law Updates and click on the all notification button to ensure that you receive the updates as soon as they are published.